is plea bargaining? Well, let's find out. Plea bargaining. In Canada, plea bargaining is a non-trial procedure that is negotiation regarding a charge, case fact, or sentencing between defendant and the Crown, or the prosecutor, in criminal courts. The accused or the defendant generally agree to plead guilty, and this is permitted for a guilty plea to reduce a charge. How often in plea bargaining is used? Surprisingly enough, 90% of criminal cases that come through the courts are resolved using plea bargaining. Actually, only 2% actually go to a criminal trial. The three overlapping categories of plea bargaining is charge bargaining, sentence bargaining, and fact bargaining. Charge bargaining. This is the reduction of a sentence with the promise that the Crown must not charge friends or family of the accused, and the Crown must not propose other charges if one is already agreed on. The defendant will plead guilty some of the charges, but the Crown must drop the other charges for a less severe charge. Sentence bargaining. This is decided by the court based on recommendations. This can be taking into consideration the defense's implied sentence, choosing a summary offense rather than an indictable offense, and allowing a hearing before the judge. This can also be if, for example, the offender could not be registered in the sex offender registry or be labeled as a high-risk offender. Generally, the defendant pleads guilty to a summary offense rather than indictable for the promise not to appeal against imposed sentence in exchange for a less severe penalty. Fact bargaining. This is information that should be presented at the sentence trial. Surprise facts is prohibited. Generally, the prior history of the accused is presented to the judge by the Crown. Moreover, this is the promises relating to the facts that the Crown may bring to the attention of the judge. What does plea bargaining look like in other countries? In Poland, this is not a pre-trial process, but rather it is during the hearing before the court. This is called voluntary submission to a penalty. But this is only valid if it is a minor offense with no more than 8 years of imprisonment. The prosecutors agree, the victim agrees, and the court agrees. In Georgia, defendant can reject the plea bargain at any stage of the criminal justice by right. This has to happen before the court proposes a judgment. In Italy, plea bargaining was introduced in the country in February 16, 1987. I apologize, I cannot pronounce that. But anyways, this is only effective to use if punishments less than 5 years of imprisonment. Now let's take a look at the process of plea bargaining in Canada. This is a conciliation between the defense attorney defending the accused and the Crown, the prosecutor. The Crown and the defense will consult an appropriate sentence in private. Then follows a period of negotiations until sentence is agreeable by both parties. In the court process, the defendant pleads guilty and a sentence is recommended by the Crown. Disadvantage about this is the judge normally favors the Crown's recommendation even though it is not required to do so. So why do we have plea bargaining? These are some reasons why we practice plea bargaining. First, to increase certainty. Judges have a wide discretion when it comes to imposing sentences. It is difficult for the Crown and the prosecutor to agree exactly what the sentence will be. The outcome of the trial, judge, or the jury decisions can be highly uncertain. To ensure that both parties achieve their most important objective. Secondly, it saves court time and saves expenses. Plea bargaining is used as a way to save the inconvenience at a criminal trial as well as the expense. Generally, the Crown will suggest a plea negotiation with trials that are lengthy and expensive. Now, what is Canada's history? Canada's criminal justice system is focused greatly on individual rights. Formerly, Canada's retributive system was first documented with a harsh punishment in Canada of a teenage girl accused of theft. and she was executed in 1649. Because of this misuse of authority and lack of rights and representation for the offenders, this was concluded that the last execution in 1972. Since then, Canada began focusing on offenders' rights and introducing plea bargaining rather than retribution. This aided more rehabilitative and incarcerations. Now, looking at the major issues in plea bargaining, what are some pros and cons? Well, the good ones are, without plea negotiations, every criminal case would go through the court, resulting in high expenses and individual denied right to a speedy trial. Moreover, cases process faster and work more efficiently. Plea bargainings also often save victims the trauma of having to go through a criminal trials, for example, in sexual assault cases. The biggest advantage to a plea bargain is to allow the justice system to breathe. If all criminal cases made it to a trial by a jury, the courts will not be able to sustain itself. They would be severely backed up by months or even years. Another advantage to a plea bargain is that it removes court congestion. Quote from Lombardo, "This is great for society because it declogs the court system for more serious cases." And there's also the bad ones. While innocent people may see plea negotiations as an easier way to resolve a case in the fear of being found guilty in trial before a judge or a jury. Moreover, the biggest disadvantage of a plea bargain is many people believe it serves no justice. People who fall victims of crime may become enraged by the small sentence that the offender receives. These people may feel that the individual was let off easy and deserves so much more severe punishment and prevents justice from being served. For example, if the defendant was charged with a third-degree murder and he was your neighbor, knowing that that defendant is going to be let off in such a short time, everyone in the community and the neighborhood would not feel safe. Furthermore, many people feel that prosecutors have too much leeway in the way they can extract guilty pleas, such as withholding potentially exculpatory evidence. Oftentimes, plea bargains are based on personal bias and abusive use of power. But how can we address plea bargain in Regina, Saskatchewan? Well, proper requirements for a case to be eligible for plea bargaining. For example, if the accused is charged for the first time with the minor drug offense, there should be plea bargaining resulting in mandatory drug treatment court opposed to court of Queen's Bench, which could result in jail time. In conclusion, the challenge if the suggestion was implemented, well, a challenge on implementing mandatory plea bargaining in first offenses would be non-cooperating offenders. Some would rather take jail over treatment. Questioning the effectiveness of specified courts and how to address recidivism. And that is it. Again, thank you for listening, and I hope you like our presentation.